5 seconds to go. Start. But is followed by two provisos A and B which deal with the different situations. As per proviso A, the in charge of police station is empowered to depute a subordinate officer to investigate the offence if he feels that the offence is not serious in nature, whereas proviso B empowers the officer in charge of police station to drop the investigation if he finds that no sufficient ground exists to enter into investigation, and in both these eventualities the concerned officer is required to submit a report before the magistrate and also to send intimation to the informant as the case may be in terms of section 157(2) CrPC. Apart from the above, the language contained in subsection 2 makes it abundantly clear that the officer in charge of the police station, after commencement of investigation, if decides to hold or stop the investigation for any reason in respect of all or any of the accused persons, then it is mandatory for such officer to furnish the report to the magistrate describing the reasons for not fully complying with the requirements of subsection 1 of section 157 CrPC. The kind of obligation conferred upon the in charge of police station makes it clear that this compliance is mandatory in nature. Section 157 CrPC was considered by the Honorable Supreme Court in its judgment rendered in Pala Singh and another versus State of Punjab 1972 AIR SC 2679, wherein it was observed that this provision has been designed to keep magistrate informed of the investigation of such cognizable offence in order to control the investigation and, if necessary, to give appropriate direction under section 159 CrPC. This view was followed by Honorable Supreme Court in State of West Bengal versus Swapan Kumar Guha and others 1982 1 SCC 561, and the relevant observation is extracted below. The position which emerges from these decisions and the other decisions which are discussed by Brother A.N. Sen is that the condition precedent to the commencement of investigation under section 157 of the code is that the FIR must disclose prima facie that a cognizable offence has been committed. It is wrong to suppose that the police have an unfettered discretion to commence investigation under section 157 of the code. Their right of inquiry is conditioned by the existence of reason to suspect the commission of a cognizable offence, and they cannot reasonably have reason so to suspect unless the FIR prima facie discloses the commission of such offence. If that condition is satisfied, the investigation must go on and the rule in Khwaja Nazir Ahmad will apply. The court has then no power to stop the investigation, for to do so would be to trench upon the lawful power of the police to investigate into cognizable offences. On the other hand, if the FIR does not disclose the commission of a cognizable offence, the court would be justified in quashing the investigation on the basis of the information as laid or received. Again, Section 157 CrPC, its nature and the law on the subject were examined threadbare by the Honorable Apex Court in State of Haryana versus Bhajanlal 1992 Supplementary SCC 335 and the relevant observations relating to the powers of police to investigate are reproduced below. The core of the above sections, namely 156, 157 and 159 of the code, is that if a police officer has reason to suspect the commission of a cognizable offence, he must either proceed with the investigation or cause an investigation to be proceeded with by his subordinate, that in a case where the police officer sees no sufficient ground for investigation, he can dispense with the investigation altogether, that the field of investigation of any cognizable offence is exclusively within which the domain of the investigating agencies, over which the courts cannot have control and have no power to stifle or impinge upon the proceedings in the investigation, so long as the investigation proceeds in compliance with the provisions relating to investigation, and that it is only in a case. Stop.